To the Standing Committee on Human Services, I'm Ken Cheveldayoff, the MLA for Saskatoon-Willow Grove, and I will be your chair this afternoon. Members of the committee are Ms. Mira Conway, the deputy chair, Mr. Mohammed Fayez, Mr. Ryan Domitar, Mr. Derek Myers, Mr. Hugh Norleen, and Ms. Alana Ross. Substituting for Ms. Mira Conway will be Ms. Vicky Mowat. I recognize Ms. Mowat.
Thank you, Mr. Chair. I would like to move an amendment that the agenda be amended by adding the following as the first item of business and rescheduling the remaining items accordingly. 3 p.m. to 6 p.m. questioning the Minister of Health regarding the provincial government's response to COVID-19 and management of long-term care.
Mowat, committee members, Ms. Mowat has moved the following motion, that the agenda be amended by adding the following as the first item of business and rescheduling the remaining items accordingly. 3 p.m. to 6 p.m., questioning of the Minister of Health regarding the provincial government's response to COVID-19 and management of long-term care. Is that agreed? No. I believe the noes have it. The motion is defeated.
Fine.
Today we will be considering 3 bills. We will first consider Bill number 19, and then we will recess briefly to change ministers and officials before considering Bills 3 and Bills 20. First bill of consideration is Bill 19. I ask the minister and his officials to take their place.
Mr. Chair, as always, I appreciate the prompt start. We will continue to be like that throughout the I'm pleased to join the members today to discuss Bill 19, the Human Resources Profession Act. Our government is on path for growth to ensure that every citizen can experience the benefits of a strong economy. To be successful, we need to support a wide variety of industries, organizations, and professions. Today with Bill 19, we are looking to ensure that we are giving our human resource professionals every advantage necessary to compete in today's market. The Act establishes 2 levels of regulation. Firstly, registration for members, and secondly, certification for those who wish to pursue the Chartered Professional Human Resources, CBHR, designation. While this legislation does not provide for licensure, it does offer the ability to protect the public interest by ensuring professional competence and ethical conduct of human resources HR professionals. Our human resource professionals already hold themselves to a high standard, but now with the ability to self-regulate, they will be able to hold their members accountable for their actions. Additionally, it increases the status and recognizes the skills and proficiency of individuals in the human resources profession. The move to self-regulation will only work to improve the level of services that employers, workers, and their families can expect when dealing with a human resource professional. Mr. Chair, our work in setting out the right legislation is an ongoing process, and we are always open to hearing from stakeholders on legislation, and we'll be proposing the following House amendments to the Act. First, we will be amending the name of the Act to, open quote, an Act respecting the human resource professionals of the Chartered Professionals in Human Resources, Saskatchewan, close quote. Second, the short title will be amended to the Chartered Professionals in Human Resources Act. Finally, Section 21 will be amended to make it clear that this Act only applies to the certification of Chartered Professionals in Human Resources. Both the Chartered Professionals in Human Resources Saskatchewan and the International Personnel Management Association Canada have jointly proposed and endorsed these amendments. I understand that the critic has been working with CPHR and IMPA Canada. I want to extend my thanks to her for her collaboration and consultation in this respect. I have said before that working together with stakeholders helps us to develop legislation that truly addresses the needs of individuals and groups, and we continue to listen and talk with stakeholders to ensure the Act is not going to impede the good work of the human resource professionals in this province. With that, Mr. Chair, I close, and I am happy to take questions to help us move forward in this legislation.
Thank you, Minister, and thank you to Mr. Tour as well. I got your name right today. Thank you to the committee members. I want to echo some of what you said, Minister, or perhaps enter into the record my appreciation for the willingness of the ministry to work through some of the considerations brought to us, particularly through the members of the IPM, and for facilitating that discussion. Very much appreciated. And I do have a copy of the letter that was sent to your ministry and I was CC'd on. So the first two changes, in fact, the first three changes are pretty straightforward, and they are, in fact, the changes that were jointly agreed to by the members of these two professional bodies. The last two amendments, I just wondered if Minister, yourself or your official could speak to the reasons for these last two amendments. So the first one being clause 10, and my apologies, my numbers don't line up with the amended numbers in the new bill. So the first being the change to clause 9, if you could describe the changes that are proposed there.
I'm not sure of where in the bill you're asking. Clause 1 of the proposed amendment deals with the name change, and then clause 21 may be what you're referring to, where it renumbers section 21.1 and then it changes the abbreviation CPHR or any word, title, or designation, so it's a definitional thing. And then it adds the following after subsection 1. Notwithstanding subsection 1, this act does not affect or interfere with the right of any person who is not a member of the association to practice in the field of human resources or to become a certified professional with the Human Resources Association other than the Chartered Professionals in Human Resources Saskatchewan. So if that's the section that you're inquiring about, the purpose of it would be that this is not an exclusive designation. You are still entitled to practice in that profession. You're just not entitled to use the name Chartered Human Resources Professional. So I would use the analogy of a person that works in a hairdressing salon. The person may have started their work there but does not have a professional designation, or they may have a professional designation, but it doesn't limit them from doing it, or they may have a designation from any one of several different accreditation bodies for it. The request that we originally received from human resources professionals in our province was based on the fact that there was a similar piece of legislation in Ontario. The Ontario human resource professionals were holding themselves out as chartered or licensed under, or maybe not use the word licensed, but were subject to the legislation in Ontario. And the inference that was made was that they were somehow superior, or that somehow people here were of a lesser standard, which certainly wasn't the case or intended to be the case. So by providing this legislation, we put the human resource professionals in our province on the same footing as they did on Ontario. It gave them the right to use that particular title that's specified in the legislation, but did not prohibit somebody else from working in the profession or from obtaining an accreditation from another entity. I don't know whether Mr. Tour wants to add something to that or whether that's...
Well, I think part of, I mean, you mentioned working with IPMA and CPHR. IPMA also has a certified member category. And I think part of the concern they were putting forward is they wanted to make it clear that their certified members were still allowed to use their title, just not Chartered Professional in Human Resources, which is the CPHR. Yeah.
Thank you, and thank you both for that that description. I'm going to admit somewhat embarrassingly on record that I was looking at amendments not to this bill. So the three that were there are the ones that were outlined in the letter, and I thank you for that. And I also was remiss in not thanking you for the technical briefing this morning with Ms. Parento and Mr. Siebert. So with Anastasia rather. So thank you for that. So I think in terms of the concerns that we had, and I will note on record that it was heartening to see the level of engagement from the professionals with this bill. I think that's always a good thing when we've got a high level of interest. We had a number of emails to our office, and I've had opportunity to speak with both organizations, and they were both very happy with the amendments as we see in front of us. So thank you for that, and sorry to give you a bit of a scare.
Acknowledge the work that was done with the different people of the ministry. Initially, when we started, both of the groups were working together and were sharing professional development, a variety of things. For whatever reason, there was a breakdown in communication, whatever, and then the bill was no longer supported by both sides. So I'm glad that they reached out. I'm glad that the parties stayed engaged and were able to find a path forward. This bill, as I think I'd indicated to you on the phone, is not a government initiative. It's requested by the profession. So I think it's our role to try and be a coach where it's appropriate, a referee where there's two competitors, but never a goalie.
Thank you for the analogy, and certainly I recognize that. And as I've mentioned in comments, this is something I do recall from lobby days, for example. This was something that was being asked for. So I'm glad to see the bill in front of us, and that those proposed amendments have been made. And I do expect that both organizations will be happy with that. I do also have a letter dated from January the 4th of this year from the Office of the Information and Privacy Commissioner. And I did have some opportunity to ask questions this morning in the technical briefing, but I did just want to get on the record and just ask what the status is in terms of the actions that were proposed and some of the amendments proposed by the Saskatchewan Information and Privacy Commissioner. Now, it is my understanding that some of the proposed changes would require a change to the template legislation. So that is understood. I just want to go through the proposed amendments and ask if there is future action that will be undertaken with regard to the concerns that have been brought forward. So the first is around subsection 18.1 and the register. And I think that this is also canvassed in a later proposed amendment, and that's around the publishing of both business addresses and potentially home addresses as well. Now, I believe that the legislation is neutral except for in one spot where it mentions both home addresses and business addresses. The proposal is to make it clear that it is a business address that would be provided to the register, given that this is something that would be published. So I'm just, I guess, looking for comment, Minister, with regard to those concerns and any future action that we might see.
The Privacy Commissioner raises two issues. One is the right of the public to know who the registrants are, what their address is, and the particulars about them. And I think that's the same with the Law Society and a variety of other entities. The template that's being used, it does not give a lot of particulars or a lot of direction on it. So it's something that in my discussions with the Ministry of Justice, they may choose at some time to do a broader consultation with the different 40-odd groups or whatever that are governed by self-governing pieces of legislation. With this particular one, and I think it was our response back to the Privacy Commissioner, or that was the nature of the discussion, was this is something that should be determined by the governing body. They should make the determination whether they want to include a business address, residential address, and the balance that the Privacy Commission was there, the individuals, the registrants' right to privacy and the right of the public to know. So his view was that it was appropriate to have the business address, and we feel that's something that's best left with the with the governing body to try and outline this in their bylaws. So we will raise the issue with them as they're preparing bylaws, which they'll have to do to complete the process, and say, how do you propose to deal with this? It's part of a broader discussion about which things should be done by way of online registries, where the records are kept at a physical location, or how much is done online. And I understand that there's some contemplation being given as to when that might be done by the Ministry of Justice. I made inquiries and they referenced that maybe this was something that should have been looked after by a previous Justice Minister. I can't comment on that.
Thank you. And just to put a fine point on it, and perhaps sort of not directly in this discussion, but this is certainly a lens that I bring to it, having worked for 15 years in domestic violence. Having access, especially if records are going to be online, it's difficult to pull them back once they're online. So if home addresses are made available, that's certainly for a number of reasons, I suppose, some that were outlined by the Privacy Commissioner, but I would just ask that that be a consideration as well.
I think that's a point that's well taken, I think the Privacy Commissioner was more than comfortable in his recommendation that we include business addresses. We don't want to do it by legislation, but we sort of want to make them aware that that's an option that should be considered.
The second subsection of note in this letter is with regard, as we were just speaking about, the electronic format. Now, the bill in its current form uses the word may, I believe, may be made available, including in an electronic format. And perhaps this is going back to the updating of the template legislation or bylaws that flow from that legislation, just noting that it's becoming increasingly the expectation that these registrars be made available online. So not as an option, but as a matter of course.
I think the point you make is a good one, and it certainly would be, I think, the preference of most people to be able to find it online. There are a number of the groups that are very small members and not having websites set up, so we would want to do consultation and then consider whether a change there would be a bill that would make all of those entities change at once. So I think we'd want to go through the process, but your point's valid.
Thank you. And just moving through systematically here, subsection 29.3, rules of the discipline committee. It talks about the discipline committee may make rules regulating its business and proceedings. There is a proposal here that that those rules include information around how private health information or private information is disclosed between parties. Is this something that would be dealt with in the bylaws then?
It would.
Okay.
I think it goes back to that fundamental expectation of privacy on those matters, and would certainly be the expectation that the bylaws would deal with what information must to ensure public transparency be made public, and what could reasonably be redacted or kept quiet.
There is an expectation, though, that private health information and private information would be redacted to some degree.
Absolutely.
Okay. Hearings in public, subsection 2914. It deals with, as you might expect, discipline committee conducting hearings in public. This is sort of adjacent to the question before. If the public is able to attend committee hearings, are they also entitled to view the documents that that are tabled in that committee?
The opinion that we have, or the justice has expressed to us, is that the section should be interpreted so that access to the documents would be not included as such, that the public wouldn't have direct information, and that adding an additional section wouldn't be appropriate. That the committee or the discipline committee would determine what things could be included, what things wouldn't, and where documents would need to be redacted or otherwise kept privileged. I think it's similar in some ways to health information. So the information of a client of a professional may have information regarding other people's personnel files, which could be incredibly personal, or it may not be health information, but it would certainly be information that would be totally inappropriate to have released. But I think the balancing part that has to be there is the public's right to know and view and become part of the hearings. So I think that would be why we would look to them to have appropriate bylaws, and look to the various other self-regulating professions to see how their bylaws are crafted, and ensure that the appropriate balance is struck.
In terms of, and thank you for that explanation. So if I'm reading the letter correctly, it would seem, yes, that the proposed amendment is about balance, that all documents in the interest of public disclosure and oversight would be public accept in instances where there's reason, specifically public health information or private information that would be disclosed.
Health information or information belonging to third parties, which might be clients of the professional or other things that are there. These are the people that would have access to an individual's personnel files, which may include performance assessments of a client's employee, or health information, disciplinary proceedings, or a variety of or other such things that would certainly be inappropriate to be released. So I think that's why you have both a disciplinary panel that would be doing their work, as well as the bylaws, which would hopefully be crafted to protect the private information in the same way that it is with the Law Society or Teachers Regulatory Board or any of the other entities.
So I guess the question that I have then is, if this is sort of a common expectation in bylaws across those professional organizations that are subject to these this template legislation, is if that is the basic expectation, is there a reason that it's kept out of legislation in bylaws?
That's probably something that might be looked at some point by the justice officials to determine whether there is a more direct way of doing it. I think by doing it by way of the bylaws have to be filed and would have to certainly be appropriate for it. And I think at the present time, for the most part, these self-governing bodies, and there's literally dozens of them, do a pretty good job of protecting and balancing the interests of their members and the members of the public. They're all subject to our various pieces of privacy legislation, both at a federal and a provincial level. And I think for the most part, they're doing it. But having said that, I think it's always worthwhile for us as a government and legislatures to look at, are we doing the best job? Are they following best practices? What's taking place in other jurisdictions? I don't think it's right for us to sit back and say, well, we'll wait until there's a breach or there's a significant issue that takes place. So I think we're aware of it, and we'll want to work with the Justice Minister to determine when or if they're going to do a legislative change, or perhaps provide some more guidance or direction with regard to how bylaws are crafted. I don't think with the number of the groups that are there, we could come up with all of the different scenarios that would take place that would have to be regulated, where information would come from, and how, what things they would have to work at, whether evidence is heard only in a verbal manner. Are they able to take sworn statements? Are they able to do things different than what hearsay rules would be? I mean, that's the reason why you have tribunals that are appointed by the government, and I think that's why self-governing entities would work with the legislation. And if there's something that becomes apparent that it doesn't work, they would have to come back to either look to the government to create a piece of a regulation, or alternatively a change to the legislation. But I think the point you raise is that when we should always be alive to it is the fact that there's potential for changes, and that this is one of the things that's an evolving area of the law.
So I think that I'm hearing that there perhaps is some willingness to look at the template legislation with regard to these. I assume that none of these are
I can't make a commitment on behalf of the current Justice Minister. I know his predecessor would have been very amenable, but no, seriously, we've asked them some of the questions, and I think they're always willing to say, okay, is this something we wait till it comes up sort of in a cycle, or is there some need to do it earlier? So.
Okay, thank you. Subsection 31.3 around decisions or orders, and this deals with whether once a ruling has been made or a decision has been made with regard to the disciplinary procedure that or process rather, whether that would be made public. For some of the reasons I think that we talked about, or you talked about, Minister, in your preamble, in terms of the role of this legislation in furthering and protecting the public. Just wondering how decisions, either under this specifically under this legislation, I understand the scope, would be disseminated.
Privacy Commissioner makes a recommendation that may find its way into further pieces of into an update to the template, but it would be something we would leave to the association to include in their bylaws as well. We think, not disagreeing with the Privacy Commissioner, that there needs to be a path forward, but it should be included in the bylaws. We haven't seen draft bylaws from yet. As with the Law Society, they're usually posted online. But it takes a period of time for somebody at the law society to go through and decide what needs to be redacted to protect the names of clients, etc. So I'm guessing that this may require the same type of process that would take place within the human resources professionals.
And I guess the next amendment that is, these are sort of recanvassing some of the same issues, but I'll just go through them. Subsection 36(4) talks about the solicitor or agent being able to obtain from the registrar a copy of documents filed. And anticipate some cost of payment in producing them, and just as again talking about that personal health information. I think we've gone through that. The subsection 36(5) talks about the hearing, the appeal hearing the same issue with the initial decision, whether that appeal would be made public. And then there's a proposed amendment around conducting appeal hearings in public. Subsection 9, the board may exclude members of the public and the person who made the complaint from any part of the hearing if the board is of the opinion that evidence brought in the presence of that person or persons excluded will unduly violate the privacy of the person. So again, striking that balance between the right to know and the right to protect personal health information, and moreover, some additional proposed amendments dealing with documents. So am I to understand then that these issues brought up by the Privacy Commissioner the expectation would be that they would be dealt with in the bylaws?
They would. It would be our intention to have the ministry give the professional body, the Privacy Commissioner's correspondence, our recommendations or our response to those which is these things properly belong within the purview of the professional body, and that the bylaws should reflect those issues, strike the balance between the privacy of third parties that may be affected, privacy of the registrant, and that balanced against the need of the public to know and to have the information available to them. So I usually, when I meet with those groups, is suggest to them that they look at the Law Society or the engineering body, which includes the various disciplinary decisions online. There's redacted portions that would affect a person's private information or health information enough that it would de-identify the individual, and that's the advice I think we would look to all of those bodies, is that they would look to finding methods of dealing with de-identifying and appropriate redactions, and that would apply not just to the evidence that's submitted, but as well to the decisions that would be rendered or whatever is included of the appeal process.
The remaining two, and just since I've gone through all of the prior suggestions, I'm going to just read these two into the record as well. But they both deal with that issue that we've already canvassed around whether best appropriate to publish the home address or business address. So I appreciate the answers, Minister, and I appreciate the answers that were provided to me in the technical briefing. And I understand that in terms of the changes, they will either be dealt with through bylaws or perhaps, if we speak with the Justice Minister, an update of the template legislation. So I think I've fully canvassed my questions on this bill. I do sincerely thank you for your time today on this bill. And I do hope that the human resource professionals in the province are happy with this legislation. And I know that they've worked hard and spent a lot of time, both prior to this and in negotiations for some of these amendments. So I do expect that they will be happy. So all that's left are my thanks, and I'm prepared to conclude my remarks, Mr. Chair.
We would be in a position that if there was an amendment being made, now would be an appropriate time.
Thank you very much, Ms. Beck. Mr. Minister, are there any more questions or comments from any other committee members? Seeing none, we will proceed. Before we proceed to clause-by-clause consideration, I've been provided with a list of amendments. And the first two amendments are to the long title of the printed bill and to Clause 1, the short title. I want to refer members to Bosque and Gagnon, House of Commons Procedure and Practice, 3rd edition, which states titles, whether it be the long, short, or alternative title, may be amended only if the bill has been so altered as to necessitate such an amendment. Therefore, the proper order for consideration of the clauses will begin at Clause 2, proceed through the bill, then come back to Clause 1, short title, and finally dispense with the amendment to the long title and the printed bill. Begin by Clause 2. Is that agreed? Clause.
You have to say carry. And then just initial right by Clause 2 right there.
Okay, let's see how many times I remember to say carried. Clause 3, is that agreed? Carried.
And initial right there.
Clause 4, is that agreed?
Carry.
Carried. Clause 5, is that agreed? Carried. Clause 6, is that agreed? Carried. Clause 7, is that agreed? Carried. Clause 8, is that agreed? Carried. Clause 9, is that agreed? Carried. Clause 10, is that agreed? Carried. Clause 11, is that agreed? Carried. Clause 12, is that agreed? Carried. Clause 13, is that agreed? Carried. Clause 14, is that agreed? Carried. Clause 15, is that agreed? Carried. Clause 16, is that agreed? Carried. Clause 17, is that agreed?
Carry.
Carried. Clause 18, is that agreed? Carried. Clause 19, is that agreed? Carried. Clause 20, is that agreed? Carried. Clause 21. I recognize Mr. Myers.
Clause 21 of the printed bill be amended by renumbering it as subsection 21(1). In subsection 1 by striking out the abbreviation CPHR or any word, title, or designation abbreviated or otherwise to imply that the person is a human resources professional member, and substituting or the abbreviation CPHR. And by adding the following subsection after subsection 1. Notwithstanding subsection 1, this act does not affect or interfere with the right of any person who is not a member of the association to practice in the field of human resources or to become a certified professional with a human resources association other than the chartered professionals in Human Resources Saskatchewan.
All right, thank you, Mr. Myers. Mr. Myers has moved an amendment to Clause 21. Do committee members agree with the amendment as read? Carried.
Just a second. Please sign and write carried on here. And then initial over the little one. Yep. An initial on top of the tape right here.
Above it?
Just like where it's taped on here. Yeah, just over the, like actually on the tape.
On the tape.
Yep, that's okay. And then initial under this, where this is on top of the written out stuff. Then again, right on top of this tape here. Like on the tape, yeah. And then, yeah, that's good. And then initial beside the whole clause. Okay. It's 21. That's a nice, yeah.
Okay, continue then. Yeah. Clause 22, is that agreed? Carried. 22.
Oh, sorry.
Carried. All right, clause 23, is that agreed? Carried. Clause 24, is that agreed? Carried. Clause 25, is that agreed? Carried. Clause 26, is that agreed? Carried. Clause 27, is that agreed? Carried. Clause 28, is that agreed? Carried. 29, clause 29, is that agreed? Carried. Clause 30, is that agreed? Carried. Clause 31, is that agreed? Carried. Clause 32, is that agreed? Carried. Clause 33, is that agreed? Carried. Clause 34, is that agreed? Carried. Clause 35, is that agreed? Carried. Clause 36, is that agreed? Carried. Clause 37, is that agreed? I'm lucky you're an agreeable bunch.
Carried.
Carried. Clause 38, is that agreed? Carried. Clause 39, is that agreed? Carried. Clause 40, is that agreed? Carried. Clause 41, is that agreed? Carried. Clause 42, is that agreed? Carried. Clause 43, is that agreed? Carried. Clause 44, is that agreed? Carried. Clause 45, is that agreed? Carried. Clause 46, is that agreed? Carried. Clause 47, is that agreed? Carried. Clause 48, is that agreed? Carried. Clause 49, is that agreed? Carried. Clause 50, is that agreed? Carried.
Clause 51 coming into force.
Clause 51 and coming into force, is that agreed? Carried.
Okay. And then we'll go back to
Clause 1, short title. I recognize Mr. Myers.
Mr. Chair, I would like to move an amendment to Clause 1 of the printed bill. Amend Clause 1 of the printed bill by striking out the Human Resources Profession Act and substituting the Chartered Professionals in Human Resources Act.
All right, thank you. Mr. Myers has moved an amendment to Clause 1. Do committee members agree with the amendment as read? Agreed? Carried.
Okay. Sign, like carried on this.
Okay. Is Clause 1 as amended agreed?
Carried.
Carried.
Okay. So initial by clause 1, right on top of this tape right here, initial, like overlapping so that it touches the tape. Yeah, perfect. And then underneath here on the part that's crossed out. Excellent.
I recognize Mr. Myers.
Thank you, Mr. Chair. I would like to move the amendment to the long title of this printed bill. The long title of this printed bill is amended by striking out profession and the chartered professionals and substituting professionals of the chartered professionals.
Mr. Myers has moved an amendment to the long title. Do committee members agree with the amendment as read? Carried.
Okay. Sign and write carried here. Your hand's probably getting sore already. Okay. And so again, right on the tape and right underneath. Okay. Good.
Good. Is the amendment to the long title agreed? Carried. Her Majesty, by and with the advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows. The Human Resources Profession Act.
Sign the top, and I'm going to get you to sign inside here as well. Her Majesty clause, just right across here. Yeah, perfect.
I would ask a member now to move that we report Bill number 19, the Human Resources Profession Act with amendment. Mr. Nerleen? Minister, do you have any closing comments?
Mr. Chair, I'd like to thank you. I'd like to thank the committee members on both sides for their time and attention to this. I would like to thank the two professional entities that work together to make this come together, the IPMA and the CPHR. They've both done a lot of work and worked together to resolve issues. I want to thank the members people that work in this building, the security staff, Ledge Assembly Services, Broadcast, Hansard, and I'm joined as well today by great folks from my office, my Chief of Staff, Jared Dunlop, Ministerial Assistant, Charles Reed, and we have a summer student, Luke Lombard, who people will know as brother, probably better than Luke, but I think we got a good deal out of the family anyway, these people that are working well to try and make government flow smoothly. I want to thank the folks at the ministry who work hard, not just today, but every day throughout the year to try and make our province grow and try and make it the great place that it is. And we can't thank them enough, and we're not aware of all the work that they do. So to them, I thank them.
Thank you, Mr. Ms. Beck.
Thank you, Mr. Chair. And thanks again, Minister, and to your officials, to Mr. Tour. I do appreciate how this problem was approached, and happy to come to a resolution here today in service of these members of this professional association, and towards the common good in this province. So with that, thank you for your time, and thanks to all the committee members for their time as well.
Committee members will adjourn very, very briefly. So recess, I'm sorry. Maybe adjourn. I could probably get that through, right? We'll recess for an additional or a very short break for cleaning purposes. Thank you.